The Supreme Court on Monday freed 3 men convicted of raping, torturing and murdering a 19-year-old Delhi woman before this was in 2012. In fact, this was months before the Nirbhaya case. The Delhi High Court had described them as predators who were walking the streets for their prey. But the Supreme Court said that the prosecution failed to prove charges and lapses occurred during the trial. The 3-judge bench went on to rule that the very identity of the accused has not been duly established by the prosecution. NDTV spoke with the victims' parents and they said that they feel like they have completely lost out in this case. And they say that they do not know what exactly went wrong. Let me go across to Ankit Tyagi, who spoke with the family. Ankit, of course one can clearly understand this. All right, we'll go across to Ankit in just a bit. Let's first listen into what the parents had to tell Ankit.
मैं आप दोनों से सबसे पहले ये पूछना चाहता हूँ, आज सुप्रीम कोर्ट का जो फैसला आया, कोर्ट के फैसले पर जब तक फैसला पढ़ा ही ना तब टिप्पणी करना मुश्किल होगा, लेकिन उन माँ बाप के लिए जिन्होंने 10 साल ये लड़ाई लड़ी है, उसके लिए आज ये कोर्ट का फैसला कितना बड़ा झटका था?
आज सुबह जब मैं कल परसों मेरे को मैसेज मिला, फोन हुआ आया कि मतलब 7 तारीख को जो है फाइनल डिसीजन सुप्रीम कोर्ट का है। आज सुबह में जब घर से निकला तो मैं कुछ अति प्रसन्न था कि आज हमें न्याय मिलेगा और न्याय जो आएगा तो वो हमारे फैसला जो आएगा वो हमारे हक में आएगा और हक में आना चाहिए था, वो आया नहीं है। क्यों नहीं आया, कारण क्या है उसका, ये तो जज जानते हैं, लॉयर जानते हैं। लेकिन जब लोअर कोर्ट से फांसी का ऑर्डर हो गया, वहां भी फाइल बनी है, वो फाइल जो है ट्रांसफर हाई कोर्ट हुआ है। हाई कोर्ट का जब फाइल पड़ी हाई कोर्ट ने तो वो उसके बाद उन्होंने अपना डिसीजन दिया है, वहां से भी फाइल ट्रांसफर सुप्रीम कोर्ट हुआ है। अब सुप्रीम कोर्ट फाइनल होता है जैसे कि एक मैच होता है कि फाइनल मैच, सुप्रीम कोर्ट फाइनल है। सुप्रीम कोर्ट इतनी बड़ी सुप्रीम कोर्ट राजधानी के बीच में, राजधानी में, और जो है कि एक इस तरह का डिसीजन इतना जल्दी ले लिया उन्होंने कि मतलब जिसने क्राइम करा उसी का सपोर्ट किया उन्होंने जी, जबकि सपोर्ट मुझे करना था, मेरी बच्ची को करना था, उनको मेरे बच्चे को न्याय दिलाना था।
अब सवाल क्योंकि सुप्रीम कोर्ट के डिसीजन के बाद यह होगा कि आपकी बेटी को क्या किसी ने नहीं मारा, क्योंकि यही 3 अभियुक्त थे
जी,
और इनको अब छोड़ दिया गया है। अब कोर्ट देखेगा कि इसमें क्या क्या सबूत थे। लेकिन आपने आज लगा आपको कि शायद आपकी निराशा हुई, आपकी बेटी को पूरा न्याय नहीं मिल पाया?
हाँ बिल्कुल निराशा हुई है, हमको न्याय नहीं मिल रहा। तो कौन मारा मेरी बेटी को, जिंदा तो है नहीं, जिंदा होती तो मेरे पास होती। अब उन पर भी तो उंगली उठ सकती है।
क्योंकि मैं समझ सकता हूँ आप लोगों को इस बात का गुस्सा बहुत है, जो भी
बहुत गुस्सा आ रहा है। क्यों है, मतलब जब लोअर कोर्ट से हाई कोर्ट से फैसला आ रखा तो ये यहाँ आके उन्होंने उनको बरी कैसे कर दिया। ये छोटे छोटे मोटे चोरी चकारी तो है नहीं, ये मर्डर केस है, रेप केस है, सब चीज कर किडनैपिंग है।
Supreme Court on Monday freed 3 men accused of gang raping and also murdering a 19-year-old girl in the year 2019 in the Chawla area, wherein the Delhi police had booked all these 3 men for allegedly gang raping and also brutally murdering a woman, and the trial court in the year 2014 had held all these 3 accused guilty and then sentenced them to death, which was again confirmed by the Delhi High Court in the month of August in the year 2014. So against the Delhi High Court order, all these 3 accused had moved Supreme Court challenging the death sentence that was confirmed by the Delhi High Court. Supreme Court, after a lengthy hearing, gave its verdict on Monday. A 3-judge bench led by then Chief Justice of India, Lalit gave this judgment wherein Supreme Court has acquitted all these three men accused of gang raping and also murdering this 19-year-old girl in the year 2012. In fact, Supreme Court has held that the prosecution failed to prove their case beyond doubt. In fact, prosecution failed during the trial proceeding. In fact, the Supreme Court has also noted glaring lapses during the trial proceedings. In fact, Supreme Court also went on to say that out of 49 witnesses that were examined by the prosecution, 10 of those material witnesses were not even cross-examined during the course of trial proceedings, and they also said that there were several glaring irregularities during the identification process of all these three accused also, and that's why noting all these three glaring lapses during the trial proceedings, Supreme Court said that the prosecution failed to prove their own case. And Supreme Court has also given some messages to the trial courts, wherein Supreme Court said that the trial court should decide cases strictly on merits in accordance with law, and courts should not be influenced by outside moral pressures, etc. The trial court should purely go based on merits in accordance with law in deciding such cases, and that's why citing all these glaring lapses, Supreme Court has said that all these three men have not been proved beyond doubt, and that's why they have acquitted all these three men who were earlier sentenced to death in this particular case.
Let me go across now to our guests who are joining us on the show. Ashutosh Srivastava, Advocate of the Supreme Court, and Mahmood Paracha, Advocate of the Supreme Court, again will be joining us shortly. Ashutosh Srivastava, coming first to you. The family says that this is a clear case of miscarriage of justice. Three people who were called predators by the High Court have been completely acquitted when the matter came up in the Supreme Court. How is this disparity in delivery of verdict possible? Because this is poles apart.
See, the Supreme Court has very well clarified that though this is a very serious issue and it is a heinous crime, there is no doubt. But at the same time, it has clarified that there have been so many of loopholes so far as the investigation and the trial of this matter is concerned. Out of the 49 witnesses, 10 of the witnesses have never been cross-examined by the defense in a proper manner, and these were very crucial witnesses to the case. Then the other materials which were collected, like the DNA report and other things, even the car which was confiscated by the investigating agency, the identity of the car has not been proved properly. So there have been a lot of lacuna and lapses during the trial. And obviously, if there is a heinous crime, but at the same time, the accused cannot be punished only on the basis of suspicion, or maybe due to some moral pressure from outside agencies. And these aspects have been considered.
That is exactly the question that I'm trying to understand. A High Court finds these three men predators, saying that they were walking the streets looking for a prey. How were they convinced of their culpability? Something that the prosecution has not been able to prove in the Supreme Court. That is the disparity I want to understand, because it's gone from one level, from a death penalty to acquittal.
See, what happens when a trial takes place, a trial court, when it reaches to a conclusion that there should be a death penalty, that death penalty cannot be given unless and until it is confirmed by the High Court. So it was confirmed by the High Court, though there was not another trial by the High Court. At the same time, as we have seen in many cases, if there are any technical issues, or if the trial is not concluded in a proper manner in accordance with law, in those cases, an accused cannot be treated to be guilty of having committed any crime. And in those cases, based on, there is two acquittal. One is respectable acquittal, and then other is acquittal based on the evidences. As we couldn't find anything against a particular person, whether that person has really committed any crime, in those cases the court may acquit that accused based on the aspects of the case that there is nothing which could be proved beyond doubt. So in this case also the same thing has been considered by the Supreme Court during hearing, and the Supreme Court found that there was no, there could have been doubts that this person these people could have committed the crime. But at the same time, there is no confirmation or eyewitness or the the proper cross-examination of the crucial witnesses in this case, which could clarify that only and only these people would have committed or have committed these kind of crimes.
But
So in
Ashutosh
those
Srivastava,
cases
then
where
what kind of an example are we setting in cases like this? And especially I want to understand from you the role of the prosecution. Does it appear that they don't take such cases seriously? I mean, in a case of rape and murder, other eyewitness, the victim herself has been killed.
Yes.
Who's going to speak for her? She's no more in the world. She's dead and
See,
gone. So
absolutely.
doesn't the responsibility fall on the prosecution to have a watertight case? Has the prosecution failed?
Yes, absolutely. I agree here that it was the duty of the prosecution to prove the case against the accused whom they arrested. Now, if the prosecution has not been able to prove it, it is the failure of the prosecution in this particular case. And whenever any person is arrested, it is expected that the particular person is not guilty of having committed crime unless and until it is properly proved during the proper trial of the case. And during the trial, it is the prosecution and the investigating agencies who are supposed to follow the guidelines and the process of law to prove that the particular accused who have been arrested have committed the crime. They have to prove with all the relevant evidences, witnesses, the collection of other evidences, circumstantial evidences, then the cross-examination of the witnesses. All these aspects have to be considered, and then only a person can be convicted by any trial court. This is the general process of law which is required to be followed by the prosecution. And now in this case, the prosecution has not been able to prove beyond doubts. Even the phone call records, the collection of the DNA, the confiscation of the car in which the girl was abducted, all these aspects have not been properly identified by the witnesses and cross-examined by the witnesses in a proper manner to say that the accused who have been arrested have only and only committed these offences. And in these kind of cases where the matter is not beyond doubt, or there is only suspicion on which the accused cannot be prosecuted or can be convicted. And in the considering all this,
help me understand, what is the redressal mechanism in this case? The Supreme Court has acquitted these three men who the High Court called predators. This is a serious issue because these men are out in the society now. And you said this is not what one would call an honorable, release. But however, they are still there, very much part of the society, and it therefore becomes a very serious matter for the entire society. What is the means of redressal?
See, even it was a suspicion, but even in that case, if they were arrested in 2012, they will be released in 2022. So whether they have committed the offence or not is still not known, considering the trial, considering the evidences and the witnesses. But even after that, they have spent around 10 years behind the bar. So in any case, they have been given certain sort of punishment, which we even don't know whether that they really deserve to be punished or not, or maybe some other people had committed that offence. So considering the suspicion, only and only suspicion, they have already undergone 10 years of imprisonment.
All right.
Now
just hold on to your thoughts there. Let me also bring in Mahmood Paracha, who's joining us here on the show now. Mahmood Paracha, I just want to understand from you, what kind of examples are we setting for our society? Rape convicts in the Bilkis Bano case have been freed. Rape convict Ram Rahim is on his third parole this year, and now the Chawla case. Is it giving women like me and many others who are watching a sense that there will be no justice for a woman in this society?
I think all of us have to step back and see the root of this problem. There are two judgments which have come recently. One is on EWS and one is this. So you can very well imagine that because SC, ST, OBC, minorities and women are hugely and vastly underrepresented in judiciary. So the result is insensitivity towards the issues of all these groups, and that is the root cause. Another reason is that in India, as our system goes, the precedents, various judgments are a maze which contradict each other, both Supreme Court and High Courts. Thirdly, it is justice by chance. Pardon me for using these harsh words, but this is a hard reality. In India, it also depends on which bench you are facing, which bench is deciding your cases. So this actually is a judgment which should become, and the court itself in the judgment saying that the ultimate aim and the cause and the reason for existence of all courts is to find out the truth. And then without the Supreme Court finding out the truth, they are just saying that because the trial court did not give a proper trial, a fair trial to the accused, because the witnesses were not cross-examined properly. So we tend to acquit them. So the appropriate procedure, according to me, would have been that Supreme Court should have used its power under 141, 142 to order a retrial, if that was their concern, to balance the issue. But as I said in the beginning, since it is a matter of concerning a woman, the sensitivity level is hugely and vastly reduced, and that is the root cause of the problem. Unless these groups are adequately represented, these kind of judgments will keep coming, even the judgments which are in favor. But let me make this clear also. In favor of these groups, women included, these judgments are not implemented. The laws which are in favor of women, these laws are not implemented in letter and spirit. Every method, every way is found out by all the authorities concerned to how to wriggle out of the rigors of these laws which have been...
And Mehmood Paracha, do you also think that the court should have wrapped the prosecution for not being able to make a watertight case in not just this crime of rape, but a brutal murder? This woman was tortured and brutalized with car tools, with earthen pots. I mean, it's a shocking case, at par with what one saw in the Nirbhaya case as well. So shouldn't that rap have come for the prosecution?
Why rap? Why not action? See, that is what I said in the beginning also, because courts are not sensitive. Why just a rap? There is no fundamental right of the victim and its family. A person who is dead loses all fundamental rights. Because the state was unable to protect her, was it her fault? So you will not, the Supreme Court, Honorable Supreme Court will not consider the rights of the victim. That is the core issue. What, not just a rap or a tap on the knuckles. There should be an action for committing such a grave mistake against the trial court. Against, what is the action they are taking?
Absolutely.
So it means that you do whatever if the weaker sections are concerned. Judiciary, police, what about the investigation? Such harsh words have been used against the investigating agency. So what about the investigators? What about the trial court? What about the public prosecutor? Nothing against them, nothing, zilch. And
Ashutosh Srivastava, that's certainly a very valid point that has been made there by Mehmood Paracha. Also because if we take your point that the matter was not dealt properly in the trial court, and if one just plays the devil's advocate, gives the benefit of doubt even to the convicts in this case, they have spent 10 years behind the bars for what the Supreme Court perhaps now believes that of crime not committed by them. In both cases, if the rape and crime of murder was committed by these three people or if it wasn't, in both cases, the prosecution should be held responsible, isn't it?
Yes, definitely. See, the Supreme Court has not said that the state cannot take any action against the investigating agency and the prosecution. The state is very much free to take actions whatever the state wants to take. The matter before the Supreme Court was not about whether the prosecution should be taken into task or anything. The matter before Supreme Court was very simple, whether these accused have committed those crimes or not, whether they should be acquitted or not.
But Ashutosh Srivastava, who is going to take this matter? I mean, the poor family members who are looking for justice, do you think that they will go back to the court saying that the prosecution did not handle our case properly? That's something that the court itself should ask for, right?
See, yes, the court has said that the trial court must follow the procedure of such kind of severe issues. But at the same time, the state is very much at liberty to take whatever actions it wants to take against the prosecution and the investigating agencies for the reasons they have failed to prove the guilt of these accused before the court
Alright.
during the hearing in Supreme Court also, and they should not have failed while collecting those evidences and for the cross-examination of the witnesses and whatever loopholes they have kept during the trial of this entire issue.
Okay.
So
All
the
right.
state
We have the
should
final
take,
few minutes left.
reasonable action.
Final few minutes left. I'll go back to Mahmood Paracha. He wants to make a point, and I also want you, Mahmood Paracha, to weigh in on this thought that I have. Are these crimes against women seen only as crimes against individuals, whereas crimes like these should be seen as crime against the state?
See, firstly, I will respond to my friend. State is at liberty. State is left at liberty. But the Honorable Bench was not at liberty to order these. In Pooja Pal's case, they've done that. Further investigation or retrial. The bench was not at liberty. And that's the exact point. So, and I fully agree with you. Actually, all crimes are against the state. It is state versus the accused persons. But in these matters where these are weaker sections of the society, the duty of the state is extraordinarily huge. Because the witnesses, this poor family of the victim will not be able to put up a good fight. So the responsibility becomes more severe of the state. And see, one more thing is there, if there is public hue and cry, like in Nirbhaya's case, if there is a lot of ruckus like in Pooja Pal's case, then the judgments are kind of different. That kind of impression is going. And if some cases are left just for the judiciary, the justice is not delivered. And I will repeat once again, the settled law that the very existence of all courts is to find out the truth. And they are going against their very existence by doing all these, by passing such kind of judgment. That's all I want to say.
All right. On that thought, we'll take a very quick break. Many thanks to both our guests for joining us here on this discussion. Taking a quick break, we'll be back with more. Stay with us.